Road to a Million. All right, hit that like, comment, subscribe. Let's get into this surf situation. Um, so I think it's about like 12. How many pages? 12 pages, right? All right, so we're gonna go through all the pages, page by page, and like get through it. Um, let's just do this first, right? Yeah, the first, all right, first line says my full name, Dejan. I request that all proceedings against me be held in that name. So they don't use his like artist name, actually. Use his real name. I understand that the Constitution and laws of the United States guarantee me the right to be represented by a lawyer. Okay, he got his lawyer. His lawyer name is right there. It's kind of a little small, but I think it says John. See, I can't really see the last one, the last name. Okay, I'm satisfied that I have enough time to discuss that matter with my lawyer. All right, so he got a lawyer, right? Fourth line, English. Okay, this it said English. Formal education stopped after. They said he employed as a artist. I have taken those on. All right, let's see. Line six. I have never been a patient in a mental hospital institution. I do not believe that at the present time I am mentally ill or mentally competent in any respect. All right, line seven. I received a copy of my indictment before being called upon to plea. I have read and discussed it with my lawyer. I understand that the substance of my charge against me is that I conspired to commit racketeering and possess firearms by a convicted felon. All right, so that's page one. Make sure I hit the like, comment, subscribe. About to get on page two. All right, so page two, right? Let's see. This is waiver of indictment. Um, Lawyer has explained that I have a constitutional charge, indictment, grand jury, but that I can waive that right, consent to being charged with criminal filed by the United States Attorney. All right, line nine. As I waive indictment, I will not be charged felony. I'm saying fines by return of indictment that there is possible cause to believe that a crime has been. All right, it said top. All right, that's another line. Let's see, 10. I also understand that if I do waive indictment, government case grand jury request the grant to indict me. On 11, I understand that a grand jury is composed of at least 16 and not more 23 persons. That at least 12 jurors find that there is probable. I also understand that the indict me. Basically, we just be on page two. We just going along. You know what I mean? So we just get a feel of what's going on. This is the waiver of indictment, page 2. Um, see. The indictment by the grand jury and these rights, and I wish to waive indictment by the grand. Okay. Let's see. Let's go to the guilty plea. Line 15. I have told my lawyer all the facts, circumstances known that in me or on me about the charge set forth in the indictment. Okay. See, I have told facts and circumstances to me charges set forth in the indictment. Satisfied I have provided that my lawyer has counseled eyes of charge possible defenses that I have this case. All right, let's go to line 17. I don't know if you see, so that's why I might kind of read too. In addition, my lawyer has explained to understand that if I enter a plea of guilty under the Constitution of laws of the United States, I will be entitled to speedy public trial, jury of 12 person charges contained in the indictment. Lawyer has explained to me stand such a trial jury told by a judge that I assume innocent and that the government required to provide guilty charges against me be stand that. All right, so this is page 2. About to go to page 3. All right, let's keep going. All right, so let's get to the next. Let's get to the next line. Let's go to line 18. Kind of cut right there. So, it's explaining to me that trying to charge trial and get the maximum. All right, so let's just go down to or as understand that if I guilty indictment and the judge accepts my waive my right to trial and the other rights set forth paragraphs 17, 18, 19, 20 and set forth. So guilty and the judge accept his plea, waive his right or the other right. Paragraph 17, 18, 19, and 20. Let's go up. 17 said that explain to a plea of see what does this say in the title of try and oh, the government. Okay. Alright. I'm aware then guilty if my guilty plea is accepted, there will be no trial, judge, judgment of after which upon consideration I can as a precinct court says that will impose punishment upon me. Stand that if I plead guilty, judgment impose the same as if I had not guilty to trial convicted by. All right, so we on line 22 right now. Just going pages. This is only page. You want to speed ahead real quick. Get up on the screen. See the next one on paragraph 22. Pause a little, see the document sentencing. All right, so I'm 20. My lawyer has informed me understand that the maximum punishment law provides for the offenses charged in this complaint indictment is a maximum of 30 years imprisonment, a fine of 500,000 for the offenses charged again. Counts 1 and 3. My lawyer has further explained stand that is oh, a mandatory minimum punishment of 20 years imprisonment, no mandatory minimum fine offenses charged in counts 1 and 3. I understand that if I plead guilty to counts 1 and 3 indictment, I face a maximum sentence of counts of 30 years imprisonment. So that's why there was he they guilty. So is that's what the title saying. Okay, so years imprisonment plus fined aggregate fine of 500,000. Okay, my lawyer actually explained, and I understand that in addition to I can't even see that one right of the penalties discussed, I may be ordered to make restitution to any victim of the offenses. Court may require to make restitution services instead of money. Make restitution designated third. Three. However, they might have cut off that last part. So this is about fines. This is page 4 right here. So I'm gonna pause a little bit. Y'all can see the page 4. See what's going on. All right, so let's see. I hereby declare that no officer or agent, any branch of government, at state or local, nor my lawyer, nor any person has made any promise or suggestion of any kind to me, or in my knowledge to anyone else, I will receive either sentence or probation, any leniency if guilty. Lawyer has explained stand on side what punishment shall receive. Has told me otherwise that the person is not telling the truth. But they be having a meetings and stuff. Like they be trying to speed these stuff up anyway. They ain't even trying. They just want you to like do some time, pay some fines, and then you. All right. I understand the sentence to be imposed upon me in the sole discretion of the sentencing judge, subject to the provisions of the Sentencing Reform Act of 1984. Damn. What else is up here? It's a whole lot of slides, man. It's like 12 slides. All right, so let's go down and discuss what my sentencing got. Trying to figure out sentencing. All right, and the court may be found to impose a statutory statutory requirements. Stand that has been. Oh, that's crazy. Damn, so they said that I on line 31 is like I understand that parole has been abolished. If I'm sentenced to prison, I will not. Oh, wow. Okay, they said I further understand that the court may impose a term of supervised release to the following to follow any term of imprisonment, and that any violation of that term supervised release may result in in an additional term of imprisonment. I understand that subject to a term of supervised release for up to 3 years. Statutory maximum period of supervised release for crimes to which I guilty. So that he was to come out supervised release 3. Even though 3 years can go by though, but it's like counts one crazy, but we have to see why he pleaded guilty to. Even though they said that they promised him and kind of like about to get. All right, hold on. We on slide 5. All right, so let's see. I understand that I will have no right to withdraw my plea on the grounds that anyone's prediction as to the guidelines range of expectation of sentence provides inaccurate. Lawyer has explained to me I understand that if I am not a citizen of the United States, my plea of guilty charge offense offenses likely result in A B. And that's if he wasn't born in the United States. But like if he was born in the United States, then he would have got like ordered and all that stuff right? On here, so he's good on the immigration law and all that stuff. That's why they put non NA. Let's go to plea agreement, right? So the plea agreement, I hereby declare that I have not been forced, coerced, or threatened in any, I can't even see that, manner by any person to plead guilty to these charges, or have I been told that if I refuse to plead guilty, other persons will be prosecuted. That is- Okay, okay, 37. There has been a plea agreement entered into between me and the United States Attorney by Assistant United States Attorney. I can't even see that. The name is like really. I don't know if I can see that. Um, let's see. Let's see. The plea agreement does exist in written form. I have read it or had it read to me. My lawyer has been explained. I hate when they be putting these stuff so damn small. All right. 18. I mean 38, my fault. 38. Substance of the plea agreement is plead to counts 1 and 3 with guideline stipulations. So I don't know. I think we about to get into the guideline stipulations next. I don't know. About to see. The agreement does contain stipulations agreed in by the parties. Okay. Check box. I understand that my plea agreement sets forth in guidelines. What's that? Calculations, which I agree is the total guidelines offense level applicable to me. In this case, they crossed out all of that, and then put both parties may argue for a variance. So we figure out what a variance is. All right, so so we on page 6. All right, paragraph 40. Well, actually, no, we gotta finish up here. But nothing was checked right there, so okay, so let's see what's checked. That was in check. Okay, so line 40. Um, I understand that my plea agreement provides that under certain circumstances I have waived my rights to appeal that collateral attack the sentence posed case. Oh yeah, just plain understand. Judge accepts from guilty plea under the plea agreement, including the government's proposal to dismiss charges or not to bring other charges. The judge is not bound to follow the other terms of the plea agreement, including the stipulation recommending that a particular sentence or sentencing range is appropriate, or that a particular provision of the guidelines does or does not apply. I understand that the judge does not follow or follow one or all of the terms of the plea agreements, including the stipulations, I will have the right to withdraw my guilty plea, even if the deposition of my case may be less favorable than that proposed in the plea agreement. I believe that my lawyer has done all that anyone could do, counsel and assist, and I am satisfied with the advice and help my lawyers have given me. Alright, so the judge will who claims to be innocent follow the count indictment team full understanding matter set for indictment application button certification action clear that reading of the indictment open court, and I request the court to enter set paragraph above. You got to go back to paragraph 43. See what 45 meant. All right, we're moving along. Page 7. So page seven, okay. So basically, the following person, if any, assisted me application, that's the lawyer that was a verified foregoing case hearing or foregoing punishment. All right, so this is the certification of counsel. So this is his lawyer, John C. Last name say. So we're gonna speed this up real quick. We don't really gotta go through All right, so this is a little. Okay, so this is basically the signing off. And this is new too. They just signed up. This is on page 9. Plea agreement with John. Schedule A. All right, so we're about to get into this page next. ROADTOAMILLMEDIA. Make sure I hit that subscribe button, like, comment. All right, plea agreement. Schedule A. Get into this one, right? Schedule A, the office, this office and Rajon recognize that the United States sentencing guidelines do not bind the sentencing judge. Each party nevertheless agrees to these stipulations. The version of guidelines effective November 1st, 2021 applies in this case. Count one, Rico conspiracy. Uh, a got one racketeering, aggravated assault. Count one racketeering, Act two, the conspiracy. Okay, I see everything right there. That's for Schedule A. Moving along, right? Because he was an organizer, lead manager, or supervisor, as described. So they got him as an organizer, lead, or manager. So because they got him as that, that's why. Count three: possession of firearms, ammunition by a convicted felon. So having a superseding indictment, A level is he committed the offense, felon conviction for of offense. Grouping of multiple counts. What is that? The sentencing for count one, including Racketeering Act 1s and 2, and count 3 are subject to the grouping rule set forth the USSG 39. Sorry, okay, group 1. The offense charging count 1. Okay, they just grouping all the counts together. Combined offense. They just basically trying to basically turn it into the Rico, basically. All right, let's keep going. We're gonna leave the page up real quick before I go to the next page. All right, let's go to the next page now. Right. All right, let's get it. As a day of this letter, Adrian has clearly demonstrated recognition and affirmative acceptance of personal responsibility for the offenses charged. Okay. 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 So this is what we gonna to right. This is what we gonna get into. Now I'm just skimming through it too, my eyes too. Therefore, then level two for assessing the responsibility and appropriate region of assessments of responsibility contains through the date of the sentencing. As of the date, as of the date of this letter, Region has assisted authorities in the investigation or prosecution of his misconduct by timely notifying. What's that? Okay, timely notifying authorized. Can't see the end of it. Authorities of his intention to enter a plea of guilty, thereby permitting this office to avoid preparing for trial. So basically, him pleading guilty, basically they don't have to go to trial now, and permitting this office and the court to allocate their resources efficiently. As at sentencing, this office will a further 1 point reduction in offense level pursuant if the following conditions are met. He enters a plea pursuant to this agreement. This office, in its discretion, determines that Rajon's assessment of responsibility has continued the day of sentencing and therefore qualifies for a 2 point reduction for acceptance of responsibility pursuant, and that Rajon offense level under the guidelines prior to the operations 16 or greater. Accordingly, the parties agree that the total guidelines offense level applicable to Rajon is 20. The total law offense level. That's just the law offense level they saying. The parties agree not to advocate for any upward or downward adjustment or departure from the guidelines range. Resulting from, I don't know what that says in parentheses, was A, the total offense level, and B, the criminal history category that the sentencing judge applies under Chapter 4 of the guidelines without any departure of or variance. But each party may seek a variance from the guidelines range, which the other party may oppose. Remember, they were seeking a variance. They said they can argue a variance, right? On the other page. That was page let me see. That was like early on. See, that was on page 5. Both parties may argue a variance. So basically, alright, so if the term of imprisonment does not exceed 63 months and except as specified in the next paragraph below, he will not be challenged or, well, my fault. He will not challenge or seek to reduce by any means any component of the sentence imposed by the sentencing judge for any reason or any efficient assistance of counsel. Term any means a direct appeal under see the codes, a motion to vacate the sentencing under 28 the statute, I believe 28 USC 255, a motion to reduce the term of imprisonment under a motion or early termination of supervised release under, and any other appeal motion. What's that? I can't even see that. It's that petition or wit, however, caption that seeks to attack or modify any component sentence if the term of imprisonment is at least 51 months, this office will not challenge by appeal, motion, or any component of the sentence imposed by the sentencing judge. Graph. Okay, the provision of this paragraph bind parties even sentencing judge employs a guidelines analyst different from the one above. But they hit the last page. Both parties reserve the right to file or oppose any appeal, collateral attack, or writ or motion not barred by the preceding paragraph or any plea agreement. However, the preceding paragraph does not apply to any proceedings to revoke terms of supervised release, motion, term, imprisonment. Alright, so basically, they saying at the end, basically saying that if the term of imprisonment at least, right? So said that can't challenge. He said if his term of imprisonment is 63 months, isn't a specified challenge. So basically, if it go charge 63 months, right, which is 5 years, charged with more than 5 years. Basically, they're saying that 5 years and accept as specified in the next paragraph below, he will not challenge or seek or reduce sentencing. Sentencing, so he can't easily challenge or seek to reduce the basically reduce the sentence. So they're saying that at the bottom it says term of imprisonment is at least 51 months. He do at least 51 months, they won't challenge it. So basically, if he 4 years, they will not challenge um it by the off. They will not challenge by appeal motion on a sentence imposed by the sentencing judge. So basically, said in paragraph 24. Um, but I don't down to 30 years. I don't know where that kind of came from. This came from like overall. If you go to trial, lose maximum sentence of 30 years because it's counts 1, 3. But that whole thing, I don't even know that last paragraph. I'm right about that paragraph. It basically saying that if he basically 4 years, they let him do 4 years and come, still gonna have to prize release. I had to still prize release. And he in the other paragraph they say he can't. I don't parole. Say he would go back to this. Alright, because this is the sentencing right. Issues right. He said the maximum is 30 years in imprisonment. 1,000. That's if he was to go to trial. Say if he go to trial and then he lose and then they give him 30 years. He would have to pay 30 years and pay 500,000. And then for the counts 1 and 3, which we went through in the earlier, right? But he pleaded guilty. Basically said he pleaded guilty to the crimes counts 1 and 3. So basically, if he can argue a variance, they say both parties can argue a variance, right? They talked about the variance in the later slides, right? So I'm about to go back to the later slides. All right, so basically they was trying to get a variance. If he can argue his variance, because the sentencing, they said sentencing is coming up. So if he can argue a variance, which they trying to argue, see, so he like right here it says like please the counts 1 and 3 with guidelines to be bottom it says both. So see something. disagreement or difference between two same legal proceeding out together. Variances are related in between decoration. Is the example of a I don't know because like sitting here I'm trying to think. So I can go back to it one more. It's 51 for this page one. Look what it says right here. It says if the term of imprisonment does not exceed 63 months and is set as specified in the next paragraph below, cause will not be challenged or seek to reduce by any means and component of the sentence imposed by the citizen judge for any reason or any ineffective assistance of counsel. Term any means includes a direct appeal under, you feel me, and a motion to vacate the sentences under 28 and a motion to reduce the term of imprisonment under a motion for early termination, supervised release under and other appeal motion, petition or writ, however, caption and seeks to attack or modify any component of the sentence. If the term of imprisonment is at least 51 months, the office will not challenge by appeal, motion, or writ, which can be the variance, any component of the sentence imposed by the sentencing judge. The provision of this paragraph bind the parties even if the sentencing judge, I think that says employees, the E so small, a guidelines analyst different from the one above. I don't know, it's a little trick in there. It's a little trick in there. But really and truly, if that's the case, it might be 4 years. It might even be three. It might even be less than that because of supervised release. It could be a couple months. You never know. It really and truly depends on what goes down on the sentencing. Um, so this is the application for permission to enter plea of guilty. And this was filed, this was like signed on like, I don't know, I think it was a couple days ago. It just hit it just hit the media like recently, so it's kind of like new. So Roads for More Media, man, hit that like, comment, subscribe, be the wave, Jersey.